Good morning, everyone, and welcome. Thank you for joining us. This is the John Burton Foundation webinar, Child Welfare 101. And I'm Deborah Pruitt, a co-organizer. We also have Devin Werble here and Debbie Raucher, and you'll hear from them a little bit later on. And so I wanted to say that this is from the California College Pathways Project of the John Burton Foundation. And we really created this webinar to help college staff who are developing the CASES foster youth programs and other programs for foster youth to help you to better understand the child welfare system and how to determine eligibility for the benefits accorded to the children that are in the foster care system. And we know how crucial these programs are because college will make the difference in life outcomes for foster youth. So we'll be highlighting eligibility for benefits. But at the same time, we knew how valuable this webinar is, so we've opened it to all of our partners in our mailing list. And so we know that there are many of you on the call who don't work at a college, but we're glad you're here. And we're hopeful that you can help steer foster youth to college over their childhood. So as we begin, I'd like to take a couple of minutes to go over some logistics. So first of all, the webinar is being recorded, and so you can listen to this again later. You can share it with colleagues as well. So the URL where the recording and the slides will be posted is at www.californiacollegepathways.org/webinars-conferences/webinars. You should be seeing that on your screen. Then I wanted to also mention if you're using your telephone, be sure to select telephone in the audio panel on the right that you should have on your screen. We highly recommend that you use your phone rather than the computer speakers because you'll have a better experience. All attendees today are in listen-only mode. This means that you're muted, so we will not be able to hear you or any sounds in your environment. We'll go through each of the panelists' presentations first, so we'll handle questions at the end of the presentation. But you're welcome to submit questions at any time. You can do so through that question section on the control panel on the right of your screen. You see the arrow pointing to that. So submit your question whenever it arises. Organize them and handle them at the end. And if you are using if you're having any difficulties, then you can use the chat section on the control panel to communicate with either myself or Devin, and we'll try to help you with any of that problem. To start off, we have a couple of good news announcements. So the state budget was just finalized a few weeks ago, and we're really pleased to say that there were $3 million additional added to expand the CHASE Education and Training Voucher Program. So this means that about 1,000 more foster youth in California will be receiving CHASE grants for going to community college. It's great news, and we know that a lot of you may have been involved in letters and calls to your representatives, so thank you for your contribution in helping make that happen. And also, there was an increase of $4 million in the infant supplement from $411 a month to $900 a month. That makes a huge difference for foster parents. Now I want to introduce today's panel. So we're really lucky. We've got three real experts to share their knowledge with us. First is Dawana Willis. She's an attorney with the Children's Law Center of California. She's going to focus on an overview of the child welfare system. And then we have Angie Schwartz, the policy director for the Alliance for Children's Rights, and she'll be explaining the different types of guardianship, permanency options, and extended foster care. And then Brian Blaylock, the law and policy coordinator at the Tipping Point community, will be covering the delinquency involved foster youth and clarify what we often call crossover youth. So with that, let's begin, and I'll turn it to Dewana for the overview on the child welfare system.
Hi, good morning, everybody. It's an honor to be able to speak to everyone today. So basically, with the first slide that we're seeing, when you talk about who enters the foster care system, it is a child that is newly born, and that is literally newly born. So a mother could have given birth a couple of days ago, and then the Department or Child Protective Services comes in and wants to file a petition on them. Also, as far as children between 0 and 17, if there are issues due to abuse or neglect, basically we have to determine whether or not there is risk to the child or to the young adult based on the parents' or guardian's behavior. Those are our clients. And as you see moving forward to the then what, it's basically our clients remain with us, or they can remain with us at this point up until the age of 21. So again, literally from 0, a very newborn, all the way to the age of 21. Next slide, please. So mandated reporters, as many of you know, those working in the education field, are individuals who work with children, and when our clients disclose information to the mandated reporters, they then must call the Child Welfare Agency. The Child Welfare Agency, based on the information received, do an investigation. They can go out to the parent's home or to the guardian's home, kind of get some more information. And if it is determined that the allegations are unfounded through the investigation that's been done, that means that whatever the information that they received does not necessarily create a risk. So that's when we have the allegations that are unfounded and or unsubstantiated. The next situation is where a family can say, yes, these things are going on, or if the investigation turns up that these things are going on, and then the Child Welfare Agency talks to the family specifically and says, look, let's try and get some services into your home. Let's try and help you corral or ameliorate the situation by doing a VFM, which is a voluntary family maintenance contract, and or a VFR, which is a voluntary reunification with the child out of the home. So they can try and work with the family. If the family does not decide to work with the Department of Children and Family Services, and they feel that a petition needs to be filed because there definitely is risk, then that is when a petition is filed and it goes to court. And then that's where typically I step in as the minor's attorney. Next slide. Basically, as you see, reasons for removal are based on majority neglect. That means that there's something going on in the home: drugs and alcohol, domestic violence, the home is uninhabitable. The parents, again, are doing something that placed their children at risk as far as the neglect is concerned. Children being left unattended at home. As far as the 6% for other, that could be where a child has actually died and has siblings. And so the Child Welfare Agency files a petition regarding the siblings, because they believe that if this child died at the hands of a parent or a guardian, then the siblings too must be at risk. Physical abuse, 9%. Emotional, we definitely see that, where the parents have really made it very difficult for their child in the home, berating them, treating them differently. We do have situations where we have one child in the home that is singled out. And then sexual abuse. Next slide. as you can see, as far as the referrals, what's substantiated and what actually comes into court is very much different. So as far as the referrals, a lot of that is, again, where you have the mandated reporters calling in and letting people know what's going on. We also have people that report, sometimes it could be one of the parents because they're unhappy about what the other parent may or may not be doing. Excuse me, as far as substantiations, those again is where the department substantiates whatever it is as far as the information based on their investigation, and those cases can be dealt with outside of court. And then we have the entries. Those are issues that must have court involvement because a parent is probably being uncooperative with Child Protective Services and, again, needs court intervention. Next slide. So the main agency, the Child Welfare Agency, makes a determination whether or not there is abuse or neglect in the home. Again, whether or not there is a risk to the child or children that are in that home due to the adult or the guardian's behavior. Once they file a petition and it comes into court, we can again have newborns all the way up to our non-minor dependents, which you're going to hear later on are 18 to the age of 21. That's where we are really attempting to have our young people be much more successful if, unfortunately, they have spent the majority of their lives in the foster care system. The other parties, again, are the parents or legal guardians. You're going to hear later on where the legal guardians can come from probate court, and for whatever reasons, because of abuse and neglect or some other reasons, they do cross over into dependency court. De facto parent is someone who has knowledge of the child and has had knowledge of the child from at least for 6 months or longer. And that individual can file a motion, it's called a de facto parent motion, to the court, letting the court know, look, this child does not have any parents at this point, but I can be the de facto parent because I have all of the information that this court would find necessary to be able to make the appropriate orders regarding the child's well-being. So they have educational information, they have medical information, they know the child's likes, dislikes, nuances, etc. The other key players are the caregivers. The caregivers can be family members. They can be what we call NRFMs, non-extended relative family members. That's typically someone who's very close to the family, a really good family friend. We have CASAs. CASAs are very important because they provide assistance with helping our youth be able to move forward in certain circumstances. For instance, if we have a child who has special needs and we need someone else on the outside, so to speak, outside of the courtroom to really help keep things moving along, that's one of the reasons why we would ask a CASA to get involved to help that child with specific issues. The education rights holder, very important, and that is something that must be addressed at every single hearing because we need to know how to ensure that our clients are getting the best educational services that they need. And unfortunately, when a parent is either absent due to being in jail or their whereabouts are unknown, or a parent just decides that they're not going to participate, we need someone to be able to step in that place. Next slide. When we get a petition, the first hearing is called a detention. That is where we in the courtroom are again reassessing the information that we get to determine whether or not there is in fact child abuse, and if there is, what can we do about that? The detention must happen within 72 hours of a child, of the department really having contact with a parent regarding whether or not the child needs to remain with a parent or in fact needs to be temporarily removed from the parent or legal guardianship's care. The next thing is we have a jurisdictional hearing. The jurisdictional hearing looks at all of the information, goes a little bit more in depth because at the detention it's just a snapshot in time. What happened with this family to bring them before the court? The jurisdiction hearing provides us a lot more information, a lot more evidentiary information, so we can determine whether or not the abuse or neglect is in fact true or some of it is true. At the disposition portion, we determine where is that child going to go and what services does the family in fact need. That can be drug counseling, parenting, individual counseling. It can be a myriad of services that the parents and or our clients, our children, also have to follow. Family reunification happens within 6 to 24 months, again, as it indicates, if there are certain exceptions that apply. A parent must be making progress to be able to get all of this time to be able to reunify. If they do not make any strides in completing their programs, then we will terminate their services and move toward a permanent plan. Permanent plan meaning adoption and or legal guardianship for our clients. It can also be long-term foster care, what we call a PPLA or a permanent planned living arrangement. Next slide. So as far as placements are concerned, we deal with our clients can be home of parent, home of parents, where the neglect and the abuse can be present but is not severe enough to remove the child from their care. So we keep just a closer eye on it when it comes into court. It kind of pushes the envelope for the family to ensure that they comply with services when it's brought into court and our clients are home of parent. Again, as far as a NRFM is concerned, that's usually somebody who's really close to the family that will be able to take care of our clients. A certified foster family agency can be twofold. They have placements that deal with our clients on a temporary basis, and they have some of our clients where they are looking to provide true permanency under legal guardianship or adoption. Group home settings are usually where we have a myriad of clients all living together in a dorm-like setting. They do have supervision and a more structured daily activities. In some circumstances, we have our clients going to school at the group homes. As far as the legal guardian, if we get to that point, then our clients will be in the care of a legal guardian and the case can remain open. We have clients with special needs that go to regional center homes where they can be in locations in a home-like setting, and that can be a permanent placement for our clients well beyond the age of 21. They can actually live there until something changes for them. Our non-minor dependents, we look at providing them with a little bit more independence where they can have their own apartments. Again, supervised by a case manager. They do have to comply with certain criteria, but again, it's a little bit more of a push for them to be more independent. And the supervised independent living, or the SILP, is where they have true independence. They go out, they find an apartment, they get X number of dollars for funding to be able to pay the rent or other necessities, and the only supervision there is where the social worker from the Department of Children and Family Services or the County Welfare Agency goes in and checks on them monthly. Their apartment does need to be approved, and it's typically where it has to meet health and safety issues. Next slide. current placements, it's more important if our clients can be with family members than it is to be in any other setting, because it makes the transition situation when they are removed from their parents that much more easier. And it's much more difficult when our clients get placed in a group home, because many of our clients are not used to a certain type of structure like that. As far as foster family agencies, they're good for our clients when we need to be able to have a more permanent home for our clients. That's when the foster family agencies are really helpful. Guardianships are also just as important as kin, because it provides a permanent plan for our clients, which is really critical, again, helping them with the transition from being removed from their parents. Next slide, please.
So now we'll change. Thank you, Joanna. That was really helpful and very thorough, clear. Now we can go to Angie Schwartz, and you can explain some of the changes that are coming in guardianship.
Sure, next slide. Hi, thank you everyone. It's great to be here this morning, and thank you to the John Burton Foundation for hosting this webinar. So the current placements that Dewana was just detailing are actually changing. Starting January 1st, 2017, any person who wants to be a foster parent, relative or not, certified through a foster family agency or through a county, will have to be approved as a resource family. So all of the certified homes of a foster family agency, the licensed homes of counties, the approved homes of relatives, the approved homes of non-related extended family members, all of those will now be resource families. All of our existing families that have already been approved or certified or licensed under the current process are going to have to convert over to the resource family approval standards. The conversion is going to happen over the course of a couple of years, and the conversion to resource family approval will be completed by December 31st of 2019. And the way that this is different is that under the new standards, it used to be that all of our families had to have pass the same criminal background check and pass the same home approval standards, but beyond that, there was a lot of discrepancy between the amount of training that they received and sort of the assessments of the individuals and the family members. And now all of our families will have a psychosocial assessment, they'll have a risk assessment, they'll have a permanency assessment, they'll continue to have the home approval and the criminal background check, and they will all have to meet training requirements. In addition, they will all be being approved as adoptive homes at the same time that they're being approved as resource families, which isn't to say they have to adopt, but they don't have to go through a new approval process if the case gets to the point that they are going to adopt later down the line. And the last thing is, once approved, all of these families will be eligible for the new foster care rates that are being developed at the state level right now, and the new rates will be based on the needs of the child. There are 4 new levels, and all of our resource families will be eligible to receive funding in the level that is consistent with the child's needs. Next slide. There are also changes to our group home placements. California is in the process of phasing out group homes for foster children and replacing them with short-term residential treatment programs, meaning all of our group homes will have to meet new licensing standards as a short-term residential treatment program in order to continue to operate and serve youth that are in foster care. And it's just what it sounds like. It's a short-term placement. It's focused on the treatment needs of young people, and really the goal is to provide interventions and support to that youth so that they can be transitioned back to a family and a community setting as quickly as possible. Next slide. There are a couple of additional issues that are important to note for foster youth that are in placement before we transition and talk about the youth that have exited foster care. The first is credit reports. It's important to know that federal and state law require social workers to do a credit report for foster youth beginning at age 14 every year. So they need to request that credit history with TransUnion and Experian and Equifax every year, and also to assist young people if there's a problem that's been identified with their credit in resolving any inaccuracies or inconsistencies. And for our non-minors, which are the young people that are over the age of 18, between 18 and 21, the county's social workers have to continue to assist the non-minors in requesting their free consumer credit report from those reporting agencies. Next slide. So as Joanna noted, there are many paths to exiting foster care. The vast majority, you can see, actually exit through reunification, meaning those services that are provided to the family are successful and the child is ultimately able to be returned home. Those who do not reunify, the vast majority of those youth still achieve permanency, either through adoption or through guardianship. And we're going to talk more about guardianship. So you can see there's two kinds there. There's other guardianship and kin gap. We're going to go into some details there. Usually, you can see it from the slide, very few of our young people are actually emancipating out of the system, meaning aging out of the system. And most of our young people are getting reunified or adopting or being adopted or entering guardianship before the age of 16. And I mention that because, as we'll be discussing a little later on, there are numerous benefits that extend beyond the age of 18, but quite a few of them require a youth to have been in foster care at age 16. So it's important to really understand what it means to be in foster care and what the benefits are that extend beyond the age of 18 and what the rules are in order to trigger those extensions. Next slide. So let's talk a little bit about the permanency options of guardianship and adoption and how those work. Next slide. So starting with guardianships, the rules on guardianships can be a little bit confusing because there's more than one type of guardianship. But the two basic questions that you can ask to sort through the issues are, is the guardianship through dependency court or probate court? And then you also need to know, is the guardianship with a relative or with a non-relative? The reason that you need to know the answers to those questions has to do with the funding and services that are available to the guardian and the youth through these two processes. So next slide. So this slide really details the difference between probate court guardianships and those cases that are referred over to dependency and may end in a dependency court guardianship. So probate court guardianships, as the name suggests, go through probate court. Probate guardianships are supposed to be used to establish a permanent or sometimes temporary living situation for a child outside of the birth or by a parent's home when it's necessary or convenient. So this happens when there's the absence or the death of a parent. It could be that the parent is in the military and is being deployed, and so they have another family member get a probate court guardianship in order to be able to act on behalf of the child. It could be a parent dies, and the person who takes custody often gets a probate guardianship. The focus of a probate guardianship is on the guardian's qualifications and on the child's needs. It is not on reunification. It has nothing to do with the parent's circumstances necessarily in terms of their ability to be a fit parent, or any preference for maintaining the family unit. Probate guardianships are not supposed to be utilized in cases where there's abuse, abandonment, or neglect. Those are the sorts of cases that are supposed to be referred over to the dependency court. And in fact, there was a court decision back in 2011, the Christian G decision, that found that there's a mandatory duty for a probate court investigator to refer a case to Child Protection Services if the investigator finds allegations that the parent is unfit. And the reason that cases of abuse and abandonment and neglect are supposed to be referred over to the dependency system, as you can see from the slide, there are many more protections for both parents and children through the dependency system. And Dewana actually detailed a lot of those protections as well. You can see on this chart how varied those protections are between the probate system and the dependency system. In dependency, guardianships are not generally ordered immediately, and that's because the parent is entitled to due process, to reunification services, to counsel. The child is also entitled to counsel. And there are many services that the family gets to receive and exhaust before we move over to an alternative permanent plan like guardianship. That said, as you probably know, there are many cases where allegations of abuse, abandonment, or neglect get referred to the probate court. And that's partly due to history, because leading up to the Christian G decision, probate guardianships were being used increasingly as a type of permanent plan and a way of avoiding foster care placements. Christian G helped to clarify what the role is of the probate court when it comes to guardianships as opposed to the dependency court. And the referral to the dependency court provides that support to families that they really need. And then ultimately, if the families can't be reunified, and you can see from the prior slide, many of them can, then dependency court can order guardianship and guardianship can still be established. Next slide. As I mentioned a couple slides ago, one of the reasons you really want to know if the case is a probate or a dependency court guardianship and if it's with a relative or non-relative is because the funding that's available to the guardian to support the youth varies according to the answers to those questions. Let's start with the relative. A relative who gets a guardianship through the probate court is actually not entitled to any additional funding different from what they could get for caring for that same child without a formal guardianship. That's because the only funding available to relatives with a probate guardianship is through CalWORKs, and sometimes the CalWORKs benefits in these cases are referred to as non-needy caregiver benefits. A kinship caregiver can get CalWORKs when they're caring for a relative's child without getting a guardianship first. CalWORKs is always available to relative caregivers without respect to the caregiver's own income and resources. But if that relative gets a guardianship through the dependency court, then they can get KinGAP funding. And you can see from the chart that the KinGAP is substantially more than the CalWORKs payment. There are some particular rules in order to qualify for the KinGAP benefit. Most notably, the child has to be in foster care and placed with that relative for 6 consecutive months before exiting to guardianship. In addition, in order to receive the KinGAP benefits, the dependency case has to be closed. While the dependency case is open, the relative would be receiving either foster care benefits or approved relative caregiver benefits, or in some counties they would be receiving CalWORKs. But once the child has been with that relative for 6 consecutive months in foster care and the case is closed to guardianship, then the relative can start receiving KinGAP. Let's talk about the non-relatives. Non-relatives who go through probate court to get a guardianship get foster care benefits, also known as AFDC FC benefits. Now remember, children who have guardianships through the probate court actually never come into foster care. So these are non-relatives that are taking guardianship through the probate system for a child who is avoiding an entry into foster care, and yet they still qualify for foster care benefits. The difference for non-relatives between a probate and a dependency guardianship, at least with regard to the funding, is really when the funding stops, not the source of assistance. For those who get guardianships as non-relatives through the probate court, the funding stops when the child turns 18. But for non-relatives who get guardianships through the dependency court, the funding continues until the age of 21, regardless of when that guardianship was established. One other benefits note for the guardians, and this is true for the dependency guardianships, whether they're relatives or non-relatives, which is that as long as that child had a foster care case at 16 or older, they're eligible for that Chafee grant when they go to college. For the ILP services to kick in, there's some different rules between the relatives and the non-relatives. For relatives to get ILP services, the child has to have been in foster care at 16 or older. But for the non-relatives, the child can be in foster care at 8 or older. Next slide. Another permanency option for youth is adoption. This slide highlights the difference between adoptions and guardianships. Basically, the adoption is the establishment of a new parental relationship and a termination of the prior parental relationship. In adoption, all the birth birth parent's rights are permanently terminated and the legal relationship with the adoptive parent is exactly the same as it was with the birth parent. In guardianships, the birth parent still has rights, and the court can end the guardianship if and when the birth parent is able and willing to begin caring for that child again. Another important difference is that guardians and guardianships can remain under the supervision of the court, and this actually happens in dependency cases quite a bit. The dependency court often orders guardianship in order to establish that legal relationship, but continues to have jurisdiction over the case in order to be able to ensure that the child and the guardian are getting appropriate supports and services. In terms of funding, children who are adopted out of foster care can receive adoption assistance benefits. That's true for both relatives and non-relatives. In both cases, the amount of the adoption assistance does not exceed what the child would have been eligible for through a foster care payment. Next slide. So foster care benefits for non-relative guardians, kin gap benefits for relatives, and adoption assistance benefits all go until the youth turns 18. The rules for when the benefits extend beyond the age 18 are a little trickier, and this chart details those rules. The first box, any youth who has that initial adoption assistance agreement signed, or any youth who has their initial kin gap payment kick in when that youth is 16 or older, can get the adoption assistance benefits or the kin gap benefits until they turn 21. So the key for AAP is when the agreement is signed, and for kin gap, it's when the payment starts. Continuing to the second box, kin gap and adoption assistance can both continue until 21 anytime a youth has a mental or physical disability that warrants continuation of assistance. And this is true no matter how old the youth is when the kin gap or the AAP, when the kin gap starts or the AAP agreement is signed. And there's no standards for what constitutes a mental or physical disability. It's anything that warrants continuation of assistance, so you can interpret it very broadly in order to support as many young people with disabilities as possible. For non-relatives who take guardianship through the dependency court, the foster care payments continue until 21, regardless of how old the youth was when the guardianship was established or when the payments began. But for, remember, the non-relatives who went through probate court, their benefits stop when the youth turns 18. And finally, if a youth turns 18 and that adoptive parent or guardian dies or stops providing support, the youth has a right to re-enter foster care and can receive assistance until 21. Next slide. So that's our extended permanency programs. Now let's talk a little bit about extended foster care. Next slide. Extended foster care, as Dawana mentioned, is the program that allows a youth to remain in foster care and receive funding, support from an attorney, case management, and court oversight until they turn 21. And in order to qualify for extended foster care, the youth has to have an order for a foster care placement on their 18th birthday. That's the magic birthday. Youth that have that order for foster care on their 18th birthday are automatically in the extended foster care program. The one exception to having that order on the 18th birthday, as I just mentioned, is for the youth that exited for guardianship or adoption, and then that individual dies or ceases to provide support beyond the age of 18. And those youth also have the ability to enter extended foster care after the age of 18. Next slide. Youth who participate in extended foster care have a number of placement options, and this actually shows you the breakdown of where youth currently participating in extended foster care are living. And you can see that 56% of youth in extended foster care are in one of our 2 supervised independent living settings. And that's either the SILP, which stands for Supervised Independent Living Program, or THP plus foster care, which stands for Transitional Housing Program plus foster care. The rest of our non-minor dependents, which is the term we use to describe a youth once they turn 18 and are continuing in foster care, are either in traditional foster homes, relative placements, or other, which I am not exactly sure what other refers to, but I'm assuming it's referring to those kids that have an open case but are between placements. Next slide. Let's talk about the most prevalent of the extended foster care placements, a SILP, which is a Supervised Independent Living Placement setting. This is the most independent of the placement options for a non-minor dependent. It is the only placement that a young person is responsible for identifying for themselves. And because there's no caregiver, there's little additional support offered to the youth. That's why it's very important that counties ensure that a young person is ready to live independently in this type of setting before approving the SILP placement. And the California Fostering Connection site, which is linked to there, actually has a readiness assessment tool available to help counties assess a young person's readiness to be in a SILP, which is really important because the foster care payment, next slide, for a SILP is actually just, well, it's just gone up, so it's actually $883 a month now because every July it goes up based on the California Necessities Index. But it's $883 a month, which doesn't go very far to meeting the monthly living expenses in many places in California. So that's why it's so critical that a youth demonstrate a plan for how they're going to meet their expenses and that they have the independence and readiness to be in that SILP. A couple other notes about the SILP benefit. It can be supplemented. There's clothing allowances that might be available depending on the county. If the young person is parenting, there's an infant supplement that they can receive in the SILP placement. It used to be $441, but as a result of the budget bill that was passed in July, it's been increased to $900 a month. And then if the young person enters into a parenting support plan, it goes up an additional $200. So that would be $1,100 a month in addition to that $883. So that's actually a pretty substantial benefit at that point. Then in the box there, just one other note, the SILP benefits that are received do not count towards the income that has to be reported on the FAFSA. Next slide. The other type of SIL, supervised independent living setting, that we have in California is THP plus foster care, which is a more supported housing model that's ideal for young people who are residing in foster care. They're participating in extended foster care, but they need some more support, so they might not be ready for the independence of a supervised independent living placement. Next slide. So there's actually 3 different types of THP plus foster care models. There's the single site, which is a complex, a building that's owned or leased by the provider, and everyone lives in their units in that building. There's remote site, which are apartments located in multiple places throughout the community. And there's also the host family model, where you actually have an adult with whom the young person has a permanent connection who's approved as the host family. And in terms of where most of our THP plus foster care beds fall, the vast majority are that remote site. 80% of our THP plus foster care beds are the remote site model. There are some college dorms that have THP plus beds at San Jose State and Santa Clara County. They have that model, and that's a really interesting model that could be replicated elsewhere in California. Next slide. So there's also a THP plus program. Note this isn't THP plus foster care. This is just our transitional housing placement plus program. This is available for former foster youth, meaning the young person has exited foster care sometime after the age of 18 and is available up until the age of 24. So a young person could participate in extended foster care and be in a transitional housing plus foster care program until 21, and then transition into the THP plus program at 21 and be there for another 2 years. There's a 24-month time limit on eligibility for THP plus, although counties do have the option of extending that up to 36 months, and they can also extend the age limit up to 25. So some counties are actually allowing young people to be in THP plus foster care till 21 and then be in THP plus until they turn 24 or sometimes 25. Next slide. Extended foster care, as I mentioned at the beginning, is an opt-out program, and what that means is that every single youth who has that order for foster care on their 18th birthday is automatically a non-minor dependent and eligible for extended foster care. But after the age of 18, a young person does not have to remain in foster care. They can opt out of the program at any time. One of the best things about California's extended foster care program is that decision to leave is available to young people with a safety net built in. And that's because under extended foster care, a youth who exits after the age of 18 can re-enter at any time. And they can re-enter an unlimited number of times, which means they really are able to sort of test their wings, and then if it's not working or if they do need that continued support of foster care again, they can come right back in and receive the protections of extended foster care. Next slide. I mentioned earlier that there are a bunch of programs and benefits that are actually available to young people beyond the age of 18, beyond extended adoption assistance benefits or extended guardianship benefits. But like those programs, a lot of these also depend on the young person actually having been in care at a certain age. So for Chafee grants, a young person has to have been in foster care at 16. That's true for the independent living program as well, with the exception being if it's a guardianship with a non-relative, then the age is 8. In order to be considered an independent for purposes of the FAFSA, any young person who's in care after the age of 13 has that status, and that's true for all of time. Whenever they're in college and completing a FAFSA, they would have that status as long as they were in foster care at 13. I should have said the Chafee grants actually only go up to age 23. And you can see the little note there that they can't have reached their 22nd birthday as of July 1st of the award year. We talked about extended foster care. Extended Medi-Cal is super important. If there's an order for foster care placement on the young person's 18th birthday, they're actually eligible for no-cost Medi-Cal benefits up until the age of 26, which is fantastic. Priority registration through our community colleges, as long as they're in foster care at the age of 18, then they're able to have that until the age of 24. And then the cooperating agencies foster youth educational support services, which are available now at 26 colleges that were selected to implement the program last year for the first time. Those services, which are really intended to help support the young person in being successful in community college, are also only available if the young person was in foster care after the age of 16, and then those services are available up until the age of 26. Next slide.
Thanks, Angie. That was really thorough and helpful. And I want to say just before I introduce our next speaker that we are running behind because, of course, there's so much important and valuable information here. So our apologies for that. And we're going to continue. Just wanted to remind you we are recording this, so if you can't stay on the call, you'll be able to listen to all the presentation and the full question and answer period on the recording. So now let me introduce Brian Blaylock, who will talk to us about delinquency-involved foster youth and crossover youth.
Great, thanks, and really appreciate that very clear overview. I'm going to do my best to talk about something that's very confusing, kind of muddy up the water. So who are delinquency-involved foster youth? Next slide. So when we talk about delinquency-involved foster youth, what we mean is kids that are involved in the delinquency system who are still have retain their foster youth status. And so the vast majority of foster children are not delinquency kids. It's actually a small percentage of overall foster youth in the state of California. And the majority of kids that are in the delinquency system usually do not have foster care status. Now, it's another question as to whether or not they should have foster care status, and I'm going to explain that in a minute. And if you're working with a youth that fits in that situation, that might actually be something that you can assist them in doing, is obtaining foster care status and then thereby getting access to many of the benefits and supports that Angie was just detailing. But really, when we're talking about delinquency-involved foster youth, we're talking about two main groups. One is foster youth who are in the dependency system, followed the process that Donna was talking about earlier in the very beginning of the webinar, and then became delinquency involved. Those kids are commonly referred to as crossover youth. they may or may not maintain their foster care status once they enter probation, which I know might sound strange. In the state of California, generally, we do not have dual jurisdiction, which means either a youth is a delinquency youth or a dependency youth, but they cannot be both. In about 17 counties right now in the state of California, they do have a kind of a modified dual jurisdiction option that either is an on-hold model, which means that the delinquency, the dependency foster care status goes on hold while the delinquency case plays out. And there's also a lead agency model, which means that either the dependency or the delinquency system will take the lead in supervising the youth while they're involved in both systems. Some counties like LA and Placer kind of have a modified mix of those two systems and use them interchangeably. In all of the other counties, not part of those 17 counties, you're either dependency or delinquency, and so if you're dependency and then you pick up a charge and you become adjudicated a delinquent, so you come into the delinquency system, then your foster care case is closed while you're in the delinquency system. The second group that we mean when we talk about delinquency-involved foster youth are those kids that may have not been in the foster care system ever on the dependency side, and the delinquency judge decides to remove them from their parent or legal guardian and place them into foster care through the delinquency system. And I'll explain more about that process in just 1 minute. Next slide. So there's lots of terminology when it comes to the delinquency system. There's lots of terminology when it comes to the dependency system as well. You may hear people referring to as 300 youth. Those are kids in the dependency system, been removed from their parent because of abuse, abandonment, neglect, in the process that we were describing much earlier in the webinar. There's also 600 youth, or sometimes 602 youth. 600 youth refer to kids who are involved in the delinquency system. 602 youth mean they actually committed a crime that if you or I as an adult committed the crime, well, it would be considered committing a crime. That is in contrast to 601 youth where they've committed the crime, and if we did it, it would not be considered a crime. Those are so-called status offenses like running away or being incorrigible. I'm certainly thankful I cannot be placed in the criminal justice system for being incorrigible, but a minor under 18 can be. Crossover youth we already defined, and then we have those dependent attorneys. And then Deborah makes a good point here about ward and the FAFSA. And so oftentimes you'll hear kids involved in the delinquency system be referred to as wards, and it's kind of used indistinguishably for kids that have foster care status and kids who do not. On the FAFSA, however, ward and dependent mean the same thing, and so it means only those kids who have foster care status. Next slide. We also run into a little bit of confusion when we talk about delinquency-involved youth having foster care status when we talk about them being placed. Not all kids in the delinquency system who are placed are foster care youth. And here in this slide, you will see there's three kind of large groups of placements that delinquency youth can be put in. The first, Camper Ranch, that's a secure placement. If you don't know anything about the delinquency system, you might think Camper Ranch sounds like a lovely place where you would have summer camp. It is not. It's kind of a cool nomenclature. In California, it refers to a facility that's part of the criminal justice system, so it's a locked facility where kids can be sentenced, although they don't say sentenced. It's where they're adjudicated delinquent and placed there. And then, of course, we also have the DJJ, Division of Juvenile Justice, which formerly used to be known as CYA, or the California Youth Authority. Those commitments have been way, way down. There's actually very few kids. Some counties, as a matter of protocol, don't send any kids to DJJ. And you can see there the numbers decreasing from 2007 to under almost 650 in 2013. The numbers are even lower now. All that to say that the middle of that array on the slides is the only thing that's considered a foster placement. And so if a youth in delinquency is placed with a relative or in a foster placement, which can include all of the array of foster care placements that we were talking about earlier, can include a relative, a NRFM, which is a non-related extended family member, a licensed non-relative, transitional housing, SILP, we were talking about earlier, so that's that $883 a month place that the youth will find themselves once they're 18 to 21. Group home, there's a couple that aren't on there, like THP plus FC or my favorite, and also the kids that I work with, the favorite, THPP, which is transitional housing for 16 to 18-year-olds. It can be a fantastic option for kids who are going to school. I had several clients who were 17 who were starting to go to a local community college to finish up their high school diploma and start getting college credits, and they were able to live in a THPP while they did that and get excellent supervision in that transitional housing. The other thing to notice there is that oftentimes in foster care placements, group homes are considered to be the highest level of restriction on the foster care world. In the delinquency world, that's not true. Group home is the highest level of restriction for foster youth in the delinquency system, but note they can also be placed in the much more restrictive Camper Ranch or the DJJ facility. Next slide. That's important too for extended foster care, which Angie was talking about earlier, because that placement on the 18th birthday has to be a foster placement. It cannot be a Camper Ranch or DJJ placement. And so in order for the delinquency court to remove and place into foster care for a child that may not have ever been in the dependency system, they do it through something colloquially called a 3C order, which is care, custody, and control. And that order is made in the delinquency court. Usually the judge will go through some sort of auctioneer speak where they say reasonable efforts have been made contrary to the interest. Care, custody, control invested in the probation department for placement in. Sometimes they say placement in a FOIA eligible facility. And then those placements can be any of the array of those things. AB 403 that was passed and went into effect this year did a great job clarifying that in the delinquency side there is a legal mandate to place in the less restrictive setting, and so when probation 2 looks at an appropriate foster care placement, they should be first looking at relatives, and if no relatives are there, then non-relative extended family members, etc., transitional housing, all of those things before they actually get to group homes. There's also such a thing as a care, custody, and control order on the delinquency side to a parent. Honestly, that's not foster care, although probably the closest corollary there would be a family maintenance case. That means they get some services in order to stay in that home. It doesn't mean they're eligible for foster care benefits or extended foster care, any of that. They are not, as long as they're placed with that parent. Next slide. So in the kind of the array of probation foster youth that probation is working with, you have those 602 youth that are on the 3C order. You also have the so-called 450 youth. That's something that wasn't on the terminology slide. That means that they were they're in a suitable order for foster care placement, and they're done with the terms of their probation, and they are at least 17.5 years old. That's 17 and 5 months. And then if that says there that the 450 youth can be supervised by probation or child welfare, it is exceedingly rare in the state of California for them to be supervised by child welfare. They're almost always supervised by probation. There are some exceptions. For example, Santa Clara County, if the youth originated in the child welfare system and then became a delinquent when they are finished with the terms of probation, if they're 17.5 and become 450s, they do go back to child welfare. The non-minor dependents there also can include those kids never on probation. Those are the ones that Angie was talking about earlier. Next slide. And just my last point, the benefits and the supports that are available to foster youth in the delinquency system are the same as the benefits and supports that are available to youth in the dependency system, as long as they have that foster care status. And so that includes credit report checks beginning at 14 years old. That includes independent living skills programs or ILP programs beginning at 16, as long as they're in foster care at 16 or after. Chafee grant eligibility, so that money for college, as long as they were in foster care through the delinquency or dependency system at 16 or after. Eligibility for transitional housing, which includes THP plus FC, 18 to 21. It includes THPP, 16 to 18. THP plus, 18 to 24, 25 at county option. And of course, it also includes those SILP placements. Angie mentioned that SILP placements, it's the only type of placement that a foster youth must go find for themselves. But also, one thing to keep in mind is while they're looking, they should also be given a placement where they can go live while they're looking. So in other words, simply, there should be no such thing as a homeless foster youth, even if they're 18 to 21, even if they're in delinquency or dependency. They should always be offered a place where they can go and live. Medi-Cal eligibility until 26, that extended foster care until 21, that independent FAFSA status as long as they were in foster care at 13 or afterwards. the priority registration also, and that priority housing access. Next slide.
Thank you, Brian. That's very helpful. And thank you all. So now we can move to the questions. And so I'm going to turn it to Devin to field some of the questions to the panelists.
Great. Thanks, Deborah. Hello, everybody. Thanks for hanging in with us today on the webinar. Got some great questions that have come in. And if you haven't put any questions in yet, you still have time. So don't hesitate. First question, I'm actually going to direct this one to Dawana. The question came in and it asks, does every child get a CASA or only those with special needs?
No, every child does not get a CASA, and unfortunately that's simply because CASAs are volunteers, and we don't always have enough volunteers to be able to help all of our clients. And no, it's not necessarily where our clients have special needs. It could be a situation kind of like a mentor situation. It could be a situation where we need someone to hold education rights, and a CASA is able to do that and step in for our clients to be able to assist them regarding any of their educational issues. So it's a myriad of issues that can come up for our clients that we feel having an extra person there outside of the courtroom to really lend a hand is invaluable.
Excellent, thank you. One more for you, Dawana. You were talking about cases and what makes it to court and severity of cases, and there was a question about, could you provide an example of what is considered not severe enough for a child to be removed? They're saying, you know, if it makes it to court, isn't that severe enough?
A situation that would not come to court, but where is again where the family, the parents, or the legal guardian is willing to work with DCFS. For instance, it could be a situation where a child was left at a school. And this is something that's happened somewhat repeatedly. The school has had to call the police, and then they feel that, okay, now we definitely need to get Child Protective Services involved. So once Child Protective Services meets with the family and it turns out that it's because mom works late and doesn't have a support system to be able to either pick up the child after school or something like that, but says, you know, I could use some help, then that's where that parent would be willing to work with the dependency court. Now, a situation where it comes into court and the child is left with the parents could be a situation where a neighbor heard the parents screaming and arguing with one another and heard some bumping. So they've contacted Child Protective Services, who comes to the door and says, you know, look, this is what we understand is going on. Your neighbor heard it once. We've done an investigation and talked to the child's school, and there seems to be some issues. If the parents are resisting, then Child Protective Services can bring the matter before the court because they need, again, to help push the issue of you really need to get some services. You need some help. You need some type of counseling, child care, whatever the situation is, and the court must then order you to do it. So that's why the court would get involved, and that's why something like that would come in, again, because the parents really need to understand services are necessary. Otherwise, we will then, in fact, seek to have your child removed from your care.
Thank you so much. The next couple questions are going to be directed to you, Angie. The one question is, I have not heard before that a youth placed with non-relatives are eligible for ILP if in care after age 8. My understanding was the age was 16. Can you clarify?
So for the non-relative guardians, they are eligible for those ILP services if the child is in care after the age of 8. And I don't really know the history of where that rule came from. I just know that that is the rule.
Great, thank you. Next one, can you, Angie, again, this is for you. Can you elaborate on the no rent charge for a THP plus foster care placement?
The no rent charge?
Right,
What does that refer to?
I guess they're not charged rent. Or Brian, did you have something?
Yeah, I'm happy. I noticed that, and I could see how that could be confusing because most of our kids that are in THP plus FC actually are charged rent, and you can't see me doing the air quotes, but I am. What that slide means is that if they're working or they have separate income, they're not required to pay that money for rent. When kids are in THP plus FC, what happens is there's an AFDCFC payment, which is the foster care payment. Then the provider may give some of that money to the youth, and then that youth would pay rent using that money. And part of that is just helping the youth get in the habit of paying rent and understanding how that works and understanding how that budgeting works. I know, for example, in the Bay, some of the providers here do that, some don't. Some do it and it's tiered, and so they may only give them the rent money and have them give that rent money right back, and then over time give them a larger and larger amount. Some will go to rent and some wouldn't. And then the money that comes back in rent, some of the providers actually save it for them, and then when they exit the program, they're actually given that money that can help them go and get like security deposit or first month's rent for the place that they move in next time.
Great, thank you. Next question, Angie, again, I have this for you. For THP plus foster care site placement, is the FFA required to sign off on a lease in order for that site to be qualified or certified?
I actually think Brian's probably better to answer that question as well.
Thank you. Do you need me to say it again, Brian? Or?
Yeah, please.
So if a young person is going into a THP plus foster care placement, does the FFA have to sign off on that placement in order for that to be qualified as a placement for a young person?
Oh, wow, that is complicated because so it wouldn't be the FFA that would need to sign off of it necessarily. So the county, whatever county agency is supervising the youth, they would ultimately need to approve the placement. And approve there just means that they're signing off on it, so they're pulling down the money in order to pay for the placement. So that can be either child welfare or probation. Some of the youth now will go out and apply for themselves for THP plus FC, and so they can get all the way through the process, but at least by the very end, the probation department that's supervising them or the child welfare department that's supervising them will need to sign off in order to be able to do that. I'm not aware of any FFA running THP plus FC placement, but I do know that some FFAs now will provide some of the can provide some of the services for kids that are in THP plus FC. For example, there's one here in Alameda County that provides EPSDT billable services. That's separate, but they don't actually sign off on the placement or do any of that stuff. That's two different things. The kid's placed in the THP plus FC, and a referral is made for EPSDT related services, and that provider provides those services in that placement.
Awesome, thank you, Brian. One more question for you, Brian. Can you explain priority housing access, I guess on your last slide that you referred to?
No, this is Debbie. I'm going to jump in here and actually answer this question, if that's okay.
Thank you.
So that just refers to, there's laws that say that foster youth get priority access to dorms. They stay in dorms over certain school breaks, that kind of thing. Essentially, all of those types of rules that apply to foster care. Probation youth who are also in foster care, those crossover youth have access to those same priority housing in the dormitories.
Perfect. Debbie, I'm going to also forward this one to you then. Under what circumstances is a youth under Code 602 qualified for KFES? Did they understand the last slide that they may also qualify for KFES programs?
Yes. So again, they have to have that dual foster care involvement. So if they're simply in the delinquency system, then they wouldn't qualify for KFES. But if they're a foster youth who also happens to have had involvement in the delinquency system, then they do qualify for KFES. Essentially, if they have that foster care status, the fact that they were also a crossover youth into delinquency in no way disqualifies them for KFES. If they only had delinquency status and they never had involvement in foster care, they would not qualify for KFES.
Perfect, great. Next question, I'm not sure who to direct it to. I'm just going to give it a whirl. I have a student in a secure setting, a ranch, is that student considered in care, in foster care, for the purposes of FAFSA while they're there? Anybody?
So placement in a camp or ranch is not a foster placement for any purpose, for funding, for Medicaid, for JP, for anything. It's actually, and I know it's actually a different section of the Welfare and Institutions Code that the judge uses in order to be able to place. So it's completely legally an entirely different thing than a foster placement.
Thank you. Next question. Let's see here. Someone in the delinquency system, are they able to obtain foster youth status? If so, how would they go about doing that? Brian, I guess this is for you.
Yeah, so the court can give them foster care status. And all that means, that's that 3C order, that care, custody, and control order. I think maybe the question is thinking about a youth who is currently on probation, has already been adjudicated delinquent, does not currently have foster care status, and is not living with a parent. And that is exactly the situation that the court can actually help with that. The public defender can file what's called a 778 order, which is a change of circumstance order, and go to the court and say, hey, court, this youth is actually a foster care youth. The court did not anticipate that at the time they made them delinquent, and so therefore they only put them on what's called a straight release order. I'm asking the court to elevate the order up to a placement order so that then probation can help this youth, support this youth with the non-parent that they're living with, or in situations that we see where the youth is homeless, probation can then help them find a placement. And so that's how a youth who doesn't have foster care status but should and is involved in the delinquency system could obtain that foster care status through the delinquency court.
Beautiful. Thank you. Debbie, I think I'm going to direct this one to you. Can you talk more about the FAFSA and declaring your independent status for a probation youth? So what paperwork should be provided? Are there things that they are not eligible for, a probation youth that a foster youth would be eligible for?
So again, if somebody is one of these crossover youth who's involved in both probation and the foster care system, they're eligible for everything that a foster youth is. They are a foster youth who happens to also be interacting with the delinquency system. So there's no difference in terms of what benefits they're eligible for, including FAFSA independent status. Now, if their foster care status came through essentially the delinquency system, it can be a little trickier to track down the paperwork. And so part of why we wanted to do this webinar was to emphasize that point. And sometimes it does take some digging to have to get the appropriate paperwork that shows that this person did have an order for foster care. And Brian, do you know, so if there's something in particular somebody should look for to have that evidence that they were in foster care if they are actually being supervised through the probation system?
Yeah, so the first step would be the ILSP or the ILP coordinator should have access, and the county should have access to the CWS CMS system. And so as long as probation put that youth into the CWS CMS system when they were in foster care, that's done, that's easy enough. And then the ILP can write a letter that certifies that the youth was in foster care. If only it was that easy. Sometimes it's not, and it particularly is not when the youth never gets into the CWS CMS database, which does happen in some counties quite a bit on the probation side. If that happens, the only way I know to be able to certify that the youth actually is in foster care is to get a copy of the minute order from the court. The public defender or probation can help with that. And it would be the minute order. So for example, if you're establishing extended foster care eligibility, you'd want the minute order that's closest to the 18th birthday in order to establish that a care, custody, and control order was made and that there was an appropriate removal and placement made in that minute order. And then you would need to use that minute order in order to establish it with whoever you needed to establish it with.
Great, thank you. Another question with, let's see here, with regards to 18 and older, legal guardianship, non-dependency, non-related children, are they eligible for THP Plus?
No, so for children who have guardianships through the probate court with a non-relative, they're not eligible for the THP Plus program because that requires having a foster care placement when you turn 18, and those youth were never in foster care.
Thank you. One last question just came in. Another one came in too. So crossover youth. This is for you, Brian. Do dates in foster care get suspended while they're in a ranch or camp, or can we count the age in the ranch as part of foster care for FAFSA, SHAFE financial aid purposes?
That's a great question. So I know, in non-dual jurisdiction counties, which I'm much more familiar with, once they're in the camp, their foster care case is closed. Once they're actually adjudicated delinquent, their foster care case is closed. And so that would stop the counting, right? And so if they were in foster care at 16, they'd have eligibility for CHAFE and ILP and all that good stuff. But then if they went to a camp and they were in a camp at 18, they wouldn't get eligibility for any of the other things that they would independently have eligibility for by being in foster care. Angie, who works more with dual jurisdiction, or Deb might know better about in dual jurisdiction counties, if there's a way to salvage that foster care eligibility while they're in camp but still have a concurrent foster care case.
Perfect, great. Well, there's some great questions. There's a couple others, and we will respond to those on our own. And I'm going to turn it back over to Deborah to close up our webinar for the day.
Thank you, Devin. And I want to say thank you again to Duana and Angie and Brian. You've provided so much valuable information that can make a difference for so many youth, so many former foster youth lives. And I'm going to highlight how valuable the slides are in those charts and graphs that you gave us, so everyone can use those going forward, even when you're not here to answer questions in these very complex cases. So thank you, and thank you all for attending. And we will post the webinar recording and the slides on the website on the screen in front of you within 24 hours, so you'll have access right away. Thank you all, and have a great day. Are you all still there?
Deborah, I'm still here. I'm just grabbing questions. This is Devin.
Okay.
Yeah, I'm just